Hello, everybody. Thanks for joining. I see the numbers of participants still rising, so just bear with us and give it another minute. I think we start in about 1 minute when the number of joining attendees have leveled a little bit further. So thanks for staying tuned. Okay, I see the number. I mean, the wonderful number, the high number of participants from all over Asia Pacific are still rising. But I think we need to get going simply because we have to cover a lot of ground. So, welcome everybody to the third episode of our webinar series on artificial intelligence, digital transformation, and law, specifically for the Asia Pacific region. Today, on IP-related issues, we will speak about certain credibility of content issues, copyright-related issues, deepfake-related issues, and that all will be presented to you by our wonderful speakers that you see on the next slide, which are in particular some up-and-coming more, I would say, younger lawyers all over the region and from Europe. So I'm very, very happy to present to you Bowen Chen, who will just make the start and speak about some very specific copyright questions. We will have PJ Kaur from our Hong Kong office with a particular focus on deepfakes and related questions. And we have Jasper Ziems from our Hamburg office going a little bit further into data scraping and related questions. And that brings me already to the content of our today's webinar. As you see on the next slide, it is AI and copyright. So some very fundamental questions: who owns what, who infringes what? Second topic, data scraping. What about the data and the legal implications of the data that is sucked in to train the models? Third, we will speak, as mentioned, about deepfakes. What are the legal implications? Who is responsible? And how do we deal with this very, very relevant topic at the moment? And finally, we will conclude on a few considerations on governance and specifically IP-related AI corporate governance questions. And then at the end of the session, we will deal with the questions from the floor. You can ask questions all along through the chat function. And you can also raise them just until the very end. If you have questions later on, you can send them by email. We will recording this session, so you will be in a position to revisit everything that will be said. And of course, at any time after the webinar, you can raise or approach any of the speaker to address whatever topic is on top of your mind. With that, we just give a very, very brief snapshot of what that all means, just to get kind of a warm up in terms of AI and copyright. This is a very recent case from the US Copyright Office called Zaya of the Dawn. You see two pictures created, the left purely by artificial intelligence, on the right a little bit edited by human intervention. The question is the human editing enough to make it copyrightable, a question the US Copyright Office had to deal with. That's all what I'm saying on this topic, because then we will move just to the spotlight of the second topic, data scraping. As we all know, these big content models need a lot of data to be pre-trained, to have the knowledge they need to spit out responses when we ask them. And this training data comes from a lot of different sources, from the internet, certainly, but it also comes from books, from encyclopedia, from movies, modal content. You see here for a number of models on the right-hand side. So different models have different just fractions of data sources. And the question is, how do we deal with the tension between who owns the data, who has some right to the data, and those who want to use the data for training purposes? And then, of course, a final snapshot into the topic of deepfake. As you see on this slide, as we all know, these models, in particular, if they are trained on a generative adversarial basis, are very, very good at imitating reality in a way that it's really, really hard to tell the real photo apart from the artificially generated, and that has a lot of legal implications. And with all that, we now deeper into the topics, and I hand over for the first topic of AI and copyright to my dear colleague, Bowen Chen. Bowen, over to you.
Thank you, Leo. Just like you said, there are many key IP issues relating to the generative AI and its outputs. For example, the legal fiction of AI as an author or inventor, the ownership of AI-generated output, and the IP protection of AI-generated output, potential infringement, maybe due to the use of third-party content as training data, and so on. Some of these topics will be included in our presentation today. But first, we want to talk about the topic of AI and copyright. And I will introduce the Chinese practice for the AI copyright protection for AI copy-generated output. In mainland China, based on the recent legal precedents, the answer of whether an AI-generated output can enjoy the copyright protection is yes. Of course, since China does not follow the tradition of case law, the analysis should be arranged on a case-by-case basis, always. In fact, the attitude of the local courts on these topics has undergone major changes. At the beginning, the court followed the international approach by giving a negative answer in the first case here, the failing case. As you can see, this case involves an analysis report automatically generated by the plaintiff using an AI tool. The court held that neither the graphics nor the textual content in this AI-generated report constitute works protected by the Chinese copyright law. The report was created by the AI tool, not by a natural person from the court's perspective. However, the court also emphasized that the fact that the report does not constitute a work does not necessarily mean that the achievement has entered the public domain and it can be used freely by the public. And the answer changed in the subsequent Tencent case. This case also relates to a financial report generated by an AI tool developed by Tencent. In the court's review, when judging whether the result involved in the case constitute a work, it is necessary to consider whether it reflects the creator's individual choice, judgments, skills, and other factors. The court held that Tencent made arrangements and choices in terms of data input, themes expressed in articles, writing styles, and other factors in the development of the AI tool. This means that during the formation of the AI-generated report, the expression actually comes from a human creator's personalized choice and arrangements. And thus, the generation process used by the AI tool met the conditions for the protection of literary works under the copyright law, and the report as the final output constitute a literary work accordingly. The third case is the most recent one and perhaps most famous one, the Springwind case. It is the first case in China for recognizing AI-generated content as an artwork. The case is a copyright infringement dispute over a picture created with a very famous AI tool, Stable Diffusion. The picture displayed on this slide is the picture involved in this case. While the court held that the essentials of people using AI models to generate images are the people use tools to make a creation. The AI-generated picture belonged to art field and had a certain form of expression. The AI-generated picture is original due to the plaintiff's personal choices in layout, composition, and many other adjustments. It also reflected the plaintiff's intellectual investment throughout the entire process of its creation. So the court held that the plaintiff has had the copyright over the generated picture. The court also mentioned that in accordance with the principle of good faith and the need to protect the public's rights to information, the plaintiff should prominently mark the use of AI technology or models on the picture. And since AI-generated outputs are already protectable, AI-assisted works should also be protectable. Nevertheless, as I just said, it is always come down to a case-by-case analysis, and it is still a developing field. And now I will pass the mic to PJ, who will introduce the Hong Kong practices.
Thanks, Bowen. So in Hong Kong, we don't yet have case law on this very specific issue, but overall, this is a very, very hot topic with the Hong Kong government's recent consultation on the copyright ordinance and AI. So in Hong Kong, in recent years, AI-generated art has gained popularities with exhibitions and auctions across town. From an IP perspective, the question then arises whether such art is protectable by copyright in Hong Kong. So the general position is that AI-generated works and AI-assisted works can attract copyright protection in Hong Kong, but where the work is purely AI generated, uncertainties remain, for example, as to who the author is. So, as I mentioned recently, there was a public consultation on copyright and AI. And by way of background, the copyright ordinance in Hong Kong distinguishes what we call LDMA works and non-LDMA works. So LDMA works are basically literary, dramatic, musical, and artistic works. And these have to be original in order to, have copyright protection. And according to the consultation paper, the government's view is that for AI-generated LDMA works, these can attract copyright protection under the necessary arranger test, the provision that's already in our copyright ordinance. So basically, what this means is that you would look at who is the person who made the arrangements necessary for the creation of the artwork, and then accordingly decide on a case-by-case basis who is the author of the computer-generated LDMA work. For non-LDMA works, similarly, the government in the consultation paper considers that the existing provisions are capable of protecting AI-generated non-LDMA works as well. For example, these include sound recordings and films, and you would typically attribute ownership to the producer, for example. So that's the position of the government in the paper on this issue. As you will see on the next slide, there are a number of questions that remain unanswered. So, for example, how do you draw the line between purely AI-generated works and AI-assisted works in terms of the human input required? And this question is there because generally, if this is really an AI-assisted work, then you would argue that copyright protection can be determined under the established traditional principles. Whereas if you're looking at a purely AI generated work, then you have to go to the more murky um, necessary arranger test. And in the absence of any case law on that provision, which has been part of the law since 1988, we don't really know how the courts are going to interpret that. So it's likely that they will look at the relevant case law in the UK, for example, which was persuasive in Hong Kong courts, to determine that question. So the second question that remains unanswered is the originality requirement appropriate for computer-generated works? Because by the very statutory definition of computer-generated works, they have no human author. So is it still appropriate to require such works to have an element of originality? So that, again, is a contradiction, I would think, in the wording of the legislation. The next question is necessary arrangers. So again, it's a very fact-sensitive analysis also, but like, how do you decide who's the necessary arranger in the context of AI specifically? You have so many parties in the chain of generation. You have the AI developer, programmer, you have the AI user who's providing the prompts, for example, and there might be other middle parties involved as well, somebody commissioning the generated work. So it all becomes quite complex. So this is where legislation, for example, would help clarify, or until we have case law, we have to grapple with these issues. With that, I will pass to Jasper to shed light on the EU position.
Yeah, thanks, PJ. So compared to the Chinese and Hong Kong copyright law we just heard, EU copyright law is a bit stricter. AI generated creations would not be protectable under a European copyright law. So if you basically just provide the prompt as a human being and not more else, and the machine, so to say, generates the whole expression, so the final product, that would be not protectable under European copyright law, because the prompt is not enough human contribution in the real creative process. But that is different, obviously, with AI assistant creations. So when, for example, AI is just used in the brainstorming phase of creating a work, that is the same legal situation as in China and Hong Kong. So copyright protection is definitely possible. As PJ just said, it is sometimes, or it will be definitely difficult sometimes in many cases to draw the exact line. What is AI generated output and what is just AI assisted output? But for AI assisted creations, copyright protection will be possible under European copyright law. That is mainly often, maybe one criterion could be when the human is in control and makes the main creative acts, and the AI is only used as a more or less technical tool like a brush or a pencil. With that, over to you, Bowen, again, and Bowen will speak about copyright infringement by AI generated output.
Yeah, thank you, Jasper. So I want to talk about something more about the copyright infringement by AI generated output. In mainland China, we are likely to have another legal precedent, the Ultraman case. The plaintiff is the exclusive licensee of the copyright in the Ultraman series images and have been granted the right to independently define its rights. While the AI tool in this case generates and displays pictures that were considered identical or substantially similar to the Ultraman series works. I attached some examples involved in this case on this slide for your easy reference. And the court in this case determined that the Ultraman works possess a strong reputation and can be accessed from multiple major online platforms. So that the defendant must be considered to have access to the original Ultraman work. And the image generated by the AI tool partially or completely reproduce the original expression of the Ultraman images, which was unauthorized, of course, thereby infringing the reproduction right of the images. And speaking of the right of adaptation, the image generated by the AI tool partially retain the original expression of the original Ultraman images and create new features based on it. As you can see in the second example on this slide, it's more like a combination of Ultraman and I think Gord Brothers, some Chinese traditional cartoon characters. So such behavior constitutes the creation of unauthorized derivative works of the prior copyrightable Ultraman works, infringing the right of adaptation. But the court also mentioned that as the plaintiff's claim for infringement against the right of reproduction and the right of adaptation was upheld, it did not consider whether the defendant had infringed the right of distribution through information networks. And speaking of the liabilities for infringement, the defendant failed to set up a complaint reporting mechanism to remind users to respect the IP rights on its terms of use agreement. And they did not mark AI-generated content so that the defendant should be held liable for damages for the infringing acts. As the defendant did not use the Ultraman images for model training, the court did not support the plaintiff's request to remove the Ultraman images from the training database. And the court also mentioned that an excessive duty of care should not be imposed on AI service providers as the defendant in the subject case. The judgment was not appealed and had become final. And now I'll pass to another speaker about their legal practice in their jurisdictions.
Thanks, Bowen. Again, in Hong Kong, we don't have case law in this yet, but to determine whether AI-generated output amounts to copyright infringement, we need to look at the acts that are restricted by copyright under the copyright ordinance. And you can see some examples. So the main one would be copying or reproducing a work or creating adaptations or so-called derivative works. So the key question in Hong Kong is whether there has been copying of a substantial part of an earlier work. So similar to mainland China, if an entire or substantial part of an earlier work is reproduced in the output, then there could be copyright infringement subject to defenses. If, however, you ask the generative AI tool to prepare a painting, for example, in the style of Picasso, it's unlikely that there will be copyright infringement. You would actually need to point to specific elements that have been copied from a specific work. Over to you now, Jesper, for the EU.
Yeah, thanks, PJ. Under European copyright law, it is more or less the exact same as under Chinese and Hong Kong law, whether an AI-generated output infringes copyright. The main question, according to the European Court of Justice, is whether substantial parts or key elements of the original work are still recognizable, so that's the threshold, recognizability, are still recognizable in the AI-generated work. And that is obviously always a case-by-case analysis. For example, in my example I chose here in this Joker example, I mean, it's up to you to judge yourself, but I would say here are the substantial parts on the left hand generated by AI picture with this headline are still recognizable in the or the original is still recognizable in the AI generated picture. So that would be maybe an copyright infringement maybe. And also, like in China and Hong Kong, just imitating the style of an artist, as PJ just said, the style of Picasso, for example, would in general, in many cases, not be an copyright infringement. With that, over to the next chapter. Generative AI and the protection needed for or against data scraping. As we can see on the next slide, we have many cases right now making headlines about the question whether data scraping is and copyright infringement. And these cases, you might all heard of the New York Times against OpenAI and Microsoft case, where the New York Times sues OpenAI for copyright infringement because allegedly OpenAI used a lot of the New York Times content to train its models. And we have these similar cases with Getty Images in image generation and, for example, Universal Music against Anthropic in the field of music. And these are US cases, but as we see on the next slide, the same questions are also relevant, very relevant to the rest of the world in the APAC region, also in the European, under European copyright law. The core question is always, is a license required to use copyright protected but publicly available content? And obviously the main legal risk are copyright infringements if I scrape these huge amounts of data on the internet and don't have any licenses to do so. But there could also be risk of data protection law violations, or maybe, depending on the exact jurisdiction, violations of the terms of services. And the right holder is somewhat between a rock and in a hard place, because on the one hand, scraping is necessary for him because the right holder or the website operator wants to be found on the internet on Google searches. But the right holder maybe don't want to be its content to be scraped. So, but it's then again hard maybe to detect the scraping and to implement technical anti-scraping mechanisms. So it comes down to the legal side of data scraping. And as you can see on the next slide, the European Union and the European Union copyright law has actually a quite modern approach when it comes to data scraping and copyright law, because there is these specific text and data mining exception. So in general, data scraping and using all these data from the internet to train AI models will be relevant for copyright law. And in general, it will be a copyright infringement. But under European copyright law, the text and data mining exception will apply. So it will be okay and justify to scrape all these content from the internet. But keep in mind, there are two different variants of the text and data mining exception. The first one is the research text and data mining exception. So if you scrape data for non-profit purposes, that is always okay. The content provider has to accept these data scraping in general. But if a company, an AI company, scrapes content and data from the internet for commercial purposes, the right holder can opt out of these data scraping. So if the right holder reserves its right in a machine readable format, so the data scraping bot can actually understand this opt out, the text and data mining exception will not apply, and it will be still a copyright infringement. Maybe it can be easily been explained with an specific example on the next slide of a recent case, because that is, I understand, quite abstract. And we just had a recent case actually dealing with these exact issues. So does the European copyright text and data mining exception applies? And the case was in Hamburg, at the Regional Court of Hamburg in Germany. And the defendant was Lion, a huge German non-profit organization, best known for its large number of large data sets for images. So big companies like Stable Diffusion use these data sets of Lion to train its text-to-image models. And the plaintiff was a German photographer who didn't want to have his images used for data scraping. He put some of his images on his website and declared actually an opt-out. So the plaintiff wanted to have his images removed and sued Lion for copyright infringement. But the court said, no, there's no copyright infringement. although the commercial text and data mining exception didn't apply because we had these opt-out I just explained you from the last slide. So the photographer was able to reserve its right in a machine-readable format. This here is a typical example. Line is a typical case for the research text and data mining exception. Line is a non-profit organization. The data scraping happened at least to the understanding of the Hamburg court mainly for research or at least non-profit purposes, and therefore the opt-out of the photographer didn't count. So it was lawful to scrape the content from the internet, at least under European copyright law. That on the next slide, just briefly, very briefly, as you might heard of, we now have this huge AI regulation, the European AI Act, and it also has some provisions on for providers of AI models of so-called foundation models, and these providers of foundation models, so OpenAI, Google, and so on, have to put in place a copyright policies. So they have to make clear how their data scraping worked. And they have to be transparent about the content they used for training their data. So there will be some template of the European Commission, and in these templates, they have to outline their content being part of their model. And with that, over to Bowen for the Chinese approach to data scraping.
Yes, thank you, Jasper. Speaking of data scraping in a mainland China's perspective, unlike EU, like Jasmine just mentioned, so far we do not have any laws or regulations defining the exception for test and data mining, as he just introduced. Regarding the legal framework in mainland China, we have the copyright law, which provides a closed category of fair use defense. It does not provide exceptions for text and data mining, and it cannot provide sufficient space for the legalization of data mining. So whether data scraping necessarily constitute infringement and whether it can apply the fair use rule under the copyright law have become the focus of controversy. And we also have an administrative measures for generative AI services, which mandates respecting copyright for data sets to train the AI tools. However, whether machine learning can apply the fair use rule is also unclear. And of course, there are also many other possible legal risks in addition to IP infringement when conducting the data scraping, such as unfair computation, violations of personal information, something like that. In China, AI copyright cases generally like at lower level courts. Many of them are internet courts with very little higher level guidance. So we believe the local authorities are still exploring effective regulatory methods on this. So there are many questions remain unanswered. For example, is image scraping unlawful, or is it the transformative use, or the potential issues with the transfer or copyright ownership of moral rights? And also, speaking of trademark infringement, is copying watermark sufficient to constitute trademark infringement in data scraping? And these are all open questions remain to be answered. Moving forward, we are expected to have more well-defined legislative rules and more higher-level court judgments as guidance. And we may also develop other possible solutions to illegally data mining, such as Creative Commons license for training data and some other rules. So we may just wait and see. And now I will pass to PJ.
Yeah, for Hong Kong, as you can see on this slide here, there are many, many players in the Gen AI chain that could be affected in case there is copyright infringement. Typically, in a data scraping claim, the rights owner would most probably pursue the AI developer. And in fact, as Jasper has mentioned, there's already major litigation by rights owners against AI companies in the US and even in the UK. For rights owners, a key challenge will be proving that their work was used to train the AI and there was copying. And in the Getty Images case, for example, you can see the Getty Images watermark on the output. And so proving that there was copying would be a little bit easier. But in other cases, this may not be the case. For AI developers and users, one aspect to watch is whether any exceptions to copyright infringement, such as data mining, fair dealing, or even temporary use, will be enacted or recognized in the AI scenario. But just looking at the current potentially relevant exceptions under the copyright ordinance right now, these are very narrow and closed in a way. So it will be very challenging to invoke these in an AI training scenario where there is likely to be excessive copying for commercial purposes. Now, there is nothing in the legislation for fair dealing that says you can't make commercial use, but this is one factor that the court looks at. So, the nature of the dealing, are you using it for a non-profit making purpose, or is it of a commercial nature, and also the amount and substantiality of the portion dealt with in relation to the work as a whole is also a relevant factor. So yes, overall it'll be very challenging. So the government in its consultation paper on the copyright ordinance has proposed a new text and data mining exception that would cover both commercial and non-commercial uses. But this has received quite some backlash from rights owners for being too broad. Perhaps one solution would be to, like the EU, which Jesper had mentioned, to allow commercial use opt-out. So we'll see what happens with that, but it's definitely a space to watch. Yeah, so moving on to the next topic, deepfakes. Definitely a hot topic lately. And you see deepfake cases being reported in the news quite a lot now. So in this part, I am going to highlight two main risks of deepfake technology. First, it's scams, and second, it's the spread of misinformation. But before that, I'd like to go over, exactly what deepfakes are. Deepfakes are basically hyper-realistic audio, video, or images which are fabricated or manipulated by generative AI. So these are things that never happened in real life. At the same time, at the outset, I want to clarify that although the word deepfakes itself has a negative connotation, deepfake technology is actually completely legitimate and has many positive applications. It can be very helpful in, for example, marketing campaigns, the film industry, and creating virtual assistants. And it has been employed for a very, very long time now. But of course, with every good thing comes the bad and the ugly. Deepfake technology can be misused by bad actors and scams or fake news, where Gen AI technology is used to manipulate an image, video recording to misrepresent somebody or something. So some of you may have heard of the Hong Kong deepfake scam case. A Hong Kong employee of a multinational engineering and design firm fell victim to a 200 million Hong Kong dollar, which is just under 26 million US dollars, deepfake fraud. And in that case, what happened was that somebody claimed to be the firm's CFO at the head office, and that person contacted an employee in Hong Kong about a confidential transaction and asked him to join a video conference with multiple people. He then convinced the employee to remit funds over 15 wire transfers to 5 different Hong Kong bank accounts. And this was all done on a pre-recorded video conference where fake voices and images were used of not just the CEO, but also other company staff. So perhaps seeing other company staff is what made it more convincing for the employee concerned. This case is now being investigated by the Hong Kong police, and the police believe that the pre-recorded video conference was generated using downloaded content of the impersonated CFO. And actually, even after instructing the employee on the pre-recorded video conference, the fraudster continued with the payment transfer instructions using other instant messaging software. So this shows that, what begins as a deep fake fraud can kind of be moved to other channels eventually. apart from scams, another major risk of deepfake technology, like I mentioned, is misinformation and fake news. So here we come to the image you see on this slide. This was in early 2024. We saw fake AI generated videos of Taylor Swift circulating on social media, giving away free sets of uh, Le Creuset cookware for a small shipping fee. But of course, there was never such any endorsement by Taylor Swift. There have also been other fake videos of celebrities promoting products and services, and so-called the false endorsement cases. So sophisticated scams and attacks like these are on the rise. The risks are real. There are major financial and reputational implications for organizations. So what can we do about this? On the next slide, you will see that um, there are some potential avenues in Hong Kong, but whether or not they would work really depends on the facts of the relevant case. Because we don't actually have specific AI or deepfakes legislation in place, but this kind of legislation is definitely top of mind elsewhere. For example, in the US, there's a lot of activity, proposals to regulate deepfakes. Even in the UK, there are offenses for sharing deepfake intimate images under the Online Safety Act. So for Hong Kong, for now, we have to look at the existing laws to identify causes of action. And the government, in its consultation paper on the copyright ordinance, had looked into this issue specifically. So one area is IP causes of action. So could you have a copyright claim? Again, the challenge would be to who do you direct this claim at? Is it the AI developer who developed the AI algorithm, or is it the user that gives prompts to generate the deepfake? You could also tackle deepfakes from a trademark perspective if you see some sort of registered trademark being used. Another potential avenue is passing off. Um, a trader may have used deepfake content to leverage a well-known person's image or likeness without consent to promote the trader's product. So this constitutes misrepresentation potentially and causes damage. Then you have a passive passing off claim. Again, this is not solely an IP issue. There are other potential causes of action. You could think about whether there's anything under the personal data protection laws, defamation, the crimes ordinance, and another powerful avenue could be the false trade descriptions, criminal offenses under the trade descriptions ordinance here in Hong Kong. Moving on to the next slide. So how do you mitigate the risks of deepfakes? So a multi-pronged strategy is required. So this should involve prevention, detection, and response. On prevention, this means raising employee awareness, first and foremost, about deepfake attacks and how they occur. Having the right verification processes is also important. If an employee receives a request to wire funds, how should this request be verified? Should the employee be using multiple communication channels to make sure that there is really such a request? Best case is, of course, face-to-face interaction, but recognizing that this is not always possible. Could the employee, pick up the phone and call the person making the request? So very practical ways you could think of. And then according to the Hong Kong police, a funny one is if there's somebody on the video asking you to, wire funds, you could actually ask the person on the video to make specific physical movements in front of the camera and then try to see if there are any abnormalities in the images. So this is the tip that the Hong Kong police had given following the earlier deepfake scam I mentioned. Detection. The idea here is to use AI to fight AI. There are many tools out there now that can detect deepfake content. And increasingly, as Jesper will tell you in a bit, there are transparency requirements under laws or guidelines that require AI developers or creators to label content that is developed using Gen AI. And many of the big AI companies have announced their intention to include metadata tags or watermarks to indicate whether or not content is AI generated. Last but not least, an incident response plan and clear reporting channels are critical. I will now hand this over to Bowen to speak about the approach to deepfakes in mainland China.
Thank you, PJ. Regarding the practice in mainland China, we have the following legal framework concerning the deepfakes. We have some laws, including the copyright law. We have personal information protection law and civil code concerning the portrait right. And we also have administrative measure on deep synthesis for internet information services. Since 2022, we have around over 20 judgments have been disclosed to the public concerning deepfakes and the so-called AI face swap. Regarding the relevant legal risks, I want to introduce a recent case in which the plaintiff are two models and the defendant's app on the phone allowed its users through an in-app paid feature to place their own faces on the blank out faces of the two models in various video templates. The reason why I want to introduce this case is because the court's attitude change in the determination of the infringement against portrait right. In this case, the court held that the defendant did not infringe on the plaintiff's portrait rights or personality rights since the phone app has removed their faces entirely in the templates, rather than distorting or defaming or forging their facial features. Because the facial features are completely replaced, the original function of identifying the plaintiff in the video was destroyed. So the public was unable to form a one-to-one correspondence between them and the plaintiff. And speaking of the infringement of personal data right, yes, given the fact that the app operator had unlawfully collected and utilized the videos containing the two models' facial features. So the app operator had violated their personal data rights. And the operator retained full control over the type and quantity of the processing of the information. And it had offered the app to users for absolutely commercial purposes. So they should be accountable for liabilities for infringement. And I think for AI company like PJ just introduced, they should pay more attention to the regulatory measures, like fulfill the obligation of identification and maybe remind the relevant public of the legal consequences of deep synthesis and strengthen their control over video resources. Now I will pass to Jasper to speak something about the EU protect.
Thanks, Bowen. Just really briefly, in the European Union, will be soon applicable a new law regarding deepfakes, a specific law with Article 50, paragraph 4 in the AI Act, and it mainly is about transparency. So deployers of AI system have to declare disclose deepfakes as AI-generated images or content. But obviously there will be an exception for law enforcement, and that is basically the main content of this provision. And with that, over to you, Leo, to AI and IP governance.
Yeah, thank you, Jasper. Well, AI governance is certainly a very big topic in any respect relating to the use and deployment of artificial intelligence. And we know that with respect to transparency, resilience, reliability, accountability. So more broadly, the question, which rule does an organization need to give themselves with regard to the use of artificial intelligence? Rules in a legal as well as in an ethical way in order to have some self-assurance that whatever they do is somehow consistent and responsible. And within this bigger realm of AI governance, just briefly shedding a light on the IP aspects, and that is only a very small fraction of the overall topic of AI governance. But also with regards to IP, we have already a number of very different issues that we need to take into consideration when shaping one's AI governance for an organization. And the first point is we need to have guidelines. So that's our rules of action for specific people. And dividing the people in the organization makes most sense in terms of how do they use artificial intelligence. In particular, are they developers on the one side, that is a more active contribution, or are they users? And for both sides, so the developers with their active contribution, as well as for the users, we need to have rules how they need to just use these tools. And we just need to know, with all we had heard before in terms of what could be infringed, what right could be generated, that there is an understanding that this translates into actions by individual people within an organization, what to do and what not to do. So guidelines for these people is very important. Second, we need legal and technical measures. So we need to realize that there are a number of things that we need to review and that we need to embed. For example, we need to have a review in order to have a good understanding of our contractual basis, on the basis of which content is in-licensed or out-licensed. Yeah. There need to be an understanding of how our data policy works in terms of making use of other people's, other organizations' data, and how other organizations may use our data. And finally, there need to be an understanding of how that is shielded technically. So both from the legal side and from the technical side, we need to have a deep understanding of how things work, and that needs to be then put in writing and made transparent. Thirdly, and very relevant in just any governance context, is training and monitoring. We need to constantly update our organization, the people in our organization, about the latest developments. So simply to be up to date on what needs to be observed, what needs to be put into action. And in addition of training, we need to monitor and have certain risk mitigation schemes in place. And finally, we need to allocate responsibility. We need to allocate competencies. We need to allocate the tasks at the appropriate level of the organization. And we take this all together. We have a nice and round framework of rules that an organization needs to observe in order to be compliant in any respect with regard to the use of artificial intelligence in the context of IP. And with that, I just start already wrapping up. And well, there might be many takeaways from that whole session. And as you see on the next slide, let's perhaps break it down to three very easy ones. Going back to the beginning of the presentation, the question, for what do we, for what can we expect to gain ownership in terms of AI supported, assisted, or generated creations? We saw differences between Europe, Hong Kong, and China, with China particularly gracious in terms of attributing copyright protection. I think somehow the bottom line, perhaps outside this, I would at this point in time perhaps call it Chinese exception. It is a little bit more that the AI assisted creation may enjoy copyright protection as opposed to the AI generated content. So that's on the copyright side. On the data scraping side, we have seen a lot of blurriness. And perhaps just to one takeaway, the terms of use that everybody gives their available data on their website, be it behind or not behind a certain wall of entrance for pay or any different. These terms of use may play a very significant roles going forward in what is legal and what is not legal in terms of scraping one's data. And finally, and stating the obvious, every company needs to really act fast and quick in order to provide themselves with an appropriate IP governance framework, and that most certainly also relates to the affected IP rights as we have shown in this presentation. And with that, I would like to conclude the presentation. And as I said in the beginning, we really welcome questions and we would like to provide answers, and you can certainly also ask questions after the presentation, but we have already seen a few questions coming in, and perhaps I start with you, Bowen, and the very, I think, very exciting news about this spring wind case you reported about, and perhaps just looking down the line more broadly outside the pure legal field. If you are very gracious to provide copyright protection to works of art that, or whatever you call, however you call them, to things that are generated by artificial intelligence, what does that mean longer terms for organization who may create such stuff? What is the commercial, what is the business-like implications by all likelihood?
Okay, thank you, Leo. First, like I said, whether the content generated by AI work depends on individual circumstances, and I'm afraid it cannot be generalized since China does not follow the tradition of case law. So the future direction of the Chinese courts may still be changed. But since we have some legal precedents like the Springwood case, like you just mentioned, to grant copyright protection for AI-generated works, I think it may at least have some positive impact on the usage of all the users, especially the professional authors, as well as companies in the related art industries that will rely more on the copyright protection, and they will have higher enthusiasm for artistic creation. And from China's perspective, since we have these legal precedents, the copyright protection issue of AI-generated content is not only a theoretical dispute, but it's more like a actual judicial practices. So I think companies can evaluate the legal risks of developing or using AI by referring to these practices. And I think this is also the case for anybody who will conduct the commercial use of AI-generated images, since the issue surrounding the nature of AI-generated content is not over. And so far, we do not have complete consensus have reached on this topic. So yes, anyone that use AI for commercial purposes may want to pay attention to the legal risks and be careful to obtain proper authorization and checking the IP-related terms of use, something like that. But I think in a more general perspective, I think it can have many positive impact on the business on the commercial side. Yes.
Thank you, Bowen. And we have, I think, time for one more question from the audience, Jasper, to you. It is about a data scraping in the EU, opting out, and what that actually means in the broader scheme. So what would you see as the medium longer term implications of that fairly gracious EU opt-out possibility and thereby just putting a very clear demarcation line? Will that be something that is the determining factor for the just the lawfulness of data scraping? How do you see the landscape?
Yeah, thanks. What we see is that compared to maybe 2 years, 3 years ago, a lot of right holders declaring these opt-out and in a really sophisticated way, like in a machine readable way, so bots can really see these opting out, understand it, and have to comply with it. So right reservations and opting out becomes more and more. And that is on the content rights holder side. And the AI companies, so to say, react to that and are striking more license deals as a reaction to these opting out and to these right reservations with big publishers. So yeah, I'm afraid like these, as you call it, these gracious text data mining exception will lose more relevance because we see more opting outs of these commercial text and data mining exception. And I'm not a US lawyer, but I could see if you have this fair use approach and this balancing of interest, and in the future, many right holders opt out of data scraping, that could shift the balance against the fair use when scraping large amount of data. But that is then again only a prediction.
Thank you so much. Thank you so much, Jasper, Bowen, and PJ, and certainly our just wonderful marketing and business development team for this session. And thank you all for joining. Please join us again for the next session that will be certainly coming up soon. With that, we concluded for now. You will receive a message with the recording and the presentation and everything. And as mentioned before, there's room for further questions. So for now, thank you and goodbye.